I'm a firm believer of miracles. And short of a miracle, there is no way that I can do this in 15 minutes and still make sense. But I'll try. So please don't focus on the slides. You're free to take them, read them at your leisure. We will just talk. So starting, I've chosen a few cases. And what I have done is, because we don't actually have a lot of precedents in IP in India, I have just taken cases which I found interesting, which have established a certain point of law. So it has changed something. It has made a believer out of people, or has asked people to give up their faith completely. So this is one of the cases. Now, the interesting part of this case was that there is a trademark registration, a shape mark, mind you. It's a shape mark for a bottle of vodka, and there is an existing design registration for the same kind of shape. Now, it's a bottle of vodka. It has an eagle on top. And while the first one, wherein the trademark, the shape mark, belongs to a Russian company, the second belongs to an Indian company. It's called Salute. The argument was that they said that, when a person goes to a bar, they know the brand, so they ask for a brand. They don't actually look at the shape and the figure of a bottle. So when they know the brand, they're asking for a brand. Why should it make a difference? But the court said that it cannot assume that just because the consumers are educated and they're going to go to a bar and ask for it for a brand, particular brand, that is no reason why we should erode the trademark or the design. Another reason was that the design registration, there was no such no search carried out for the trademark. So in this particular case, it was established that the infringement was happening and they would not let it happen. So Gorbachev vodka, they have prevailed in spite of their trademark application still being pending, and the design registration was revoked. So this was one of the cases. Going on to Faber-Castell. Now, this was another very interesting case because the difference was very little. Faber-Castell and Cello, if you've seen the crayons, they are a little triangular. They look a little like miniature Toblerones. Not to be eaten, but nevertheless. And they had these parallel lines. And the Faber-Castell had a small logo at the back. Cello obviously did not. The argument used by Cello was that these three lines, they provide a better grip for the crayon. The court observed and said that no, we can't do that. We cannot have this for the simple reason that normally the person who's going to buy crayons is a parent, and in all likelihood, a very harassed parent. And there is no way that they are going to look for those three lines of the Faber-Castell logo. So we cannot have that. So this went in favor of Faber-Castell. Further, there was another stay application. They wanted, a stay application so that they could possibly get rid of all the Cello crayons that they had already there in the stock. The court did not allow this either. It simply said that this is just not allowable because Cello wants to liquidate its existing inventory, which is just not fair to Faber-Castell. So in this particular case, again, went in the favor of Faber-Castell. Now we'll go to patents. I believe that India is a very, very emotional country. You package anything in India in an emotional packaging and it'll sell. Unfortunately, lately we have become a very prudish country. But I'm still going to be talking about an example which doesn't happen to be Indian. The example happens to be about breast implants. Breast implants started in Japan in the year 1950s. And then they finally came to US and the rest of the world. Because they were treated as medical devices, in 1976, I think, they came under the regulation of FDA in United States of America. Now the thing was that normally FDA would carry out certain regulations, but in this case, because these devices had been used for a very long time and there had been no problem because they were being used in contact lenses and otherwise also, so FDA did not carry out any test. This was 1976. The trouble started about 10 years down the line. And the first reports came in from Japan, followed by Australia, and then from San Francisco, and then there were women who were saying that possibly these implants are causing cancer. Suddenly, implants became a problematic issue. Early 90s, one woman in San Francisco sued Dow Corning, which was a major provider for this, for about $2.5 million. She was granted that. Then there were a few people who came on some CBS shows, and there were women who were talking about pain and humiliation and so much of problems. So people were talking about these bombs. They literally became like bombs. It was the next worst thing to happen to humanity after cigarettes. And the sad thing was that the FDA told everyone to give their evidence. The evidence that they collected was not sufficient, was not considered sufficient. And then in 1995, Dow Corning declared bankruptcy because the floodgate had opened. There were so many litigations. There were so many people who were saying that this is what is making me sick. But there was no evidence. There was no epidemiological evidence which was required to establish that it is silicone implants which is causing this. Finally, in early 2000, epidemiological evidence came into being, and it was established that silicone implants do not cause breast cancer. Pain, emotion is all very well, but it is no replacement for reason and evidence. Reason and evidence is what makes jurisprudence. So we'll go through some of the patent cases, and we will talk about them in view of that. So we all know about the Novartis case. Everyone's talked about it. I think you can read the slides a little later. The important part was that this is the first time when Supreme Court actually went into Section 3D and gave very clear directive that it is therapeutic efficacy we are looking at. So if you're looking at higher shelf life, if you're looking at anything else, please don't look at it. We are looking at therapeutic efficacy per se when we are looking for a drug. So this was the first time that we got some hint as to how things are. Now, another reason why we keep talking about, everyone knows that intellectual property is a secondary right. But right to property in India was introduced as a fundamental right and was revoked. So right to property is not a fundamental right in India, which means that you have to go to courts. You have to take interpretations from the court. It is not something which has been given to you on a platter. So this is the observance of the apex court. The surprising part, which I don't know, hasn't found mention anywhere, is that apart from beta form, there was an alpha form also, which was filed by Novartis, but it was like started with a bang, ended with a whimper, but there was nothing done on alpha form. The UCB case, if you look at this was especially because for pre-grant oppositions. Pre-grant oppositions became quite a bane because there were n number of pre-grant opposition. The person interested did not have to be established. It could be anyone. Anyone could file a pre-grant opposition, an n number. So, and the Act does not clarify that what will the patentee or the patent application, the respective person, do in case the pre-grant opposition is not in his or her favor. So this case was important because it clarified. Person interested, in that case, you obviously can go for post-grant opposition, and you can go for revocation. If in case you are a third party, not a person interested, which is a possibility in case of pre-grant opposition, then you don't have a remedy except for a writ petition, which I think is perfectly fair. And then in case a pre-grant opposition is accepted, then you can go to IPAB. It will be treated as any other Section 15 decision. So I think this particular case kind of clarified of how we are going to go about pre-grant, post-grant, and revocation proceedings. So this was one of the landmark judgments. We go to Chemtura. This was the Pandora's box. This was the Section 8, and it came out. And everybody started writing, and you have to give everything, each and every document that you can think of, that you have filed in a corresponding application, you must file it. No, it is not like that. It is about the intent. It is about the purport. If you have malified intention, the court will recognize that. But if then you have missed out something, it's absolutely okay. Which is why, like Mr. Dressel mentioned, eventually the courts have exercised discretion. We'll come back to that again. Okay, now this is, again, La Roche case. So, whatever happened, I think everyone's talked about it. I'll go to the judgment. This is one of the judgment because it's a single, it was single bench presided by Justice Butt. And this was hailed by NGOs. It was almost akin to creating a compulsory license. Because here, for the first time, apart from the plaintiff and the respondent and the defendant and whatever, third party has been given a lot of importance. It is being said that no, such degree of harm it cannot be contemplated and everything else. So this judgment was actually a very big problem, especially when you're looking at an international market. Because here, this is something which can truly qualify for judicial activism. But thankfully, we have a double bench judgment, which has come on November 27th. And in conclusion, for one, they have really cleared on how, we are going to interpret inventive step. The most interesting part which I found was that the judgment was plagiarized. And eventually, both of the judges, thankfully and very honestly, they have accepted that particular portions of judgment have been copied from a particular journal. So this was a very interesting phenomena that happened. Okay, Bayer versus Cipla, the same case, generic versus the originator, the patent linkage case where we are talking about the Director General of Drugs. It was very clearly established that there will be no overlapping between the two. The Patent Act is different. The Drug Control Authority is different. There was not supposed to be an overlap between the two. The legislators did not want that. We know that such provisions exist in the US, but we do not want it for ourselves, period. So this controversy has been laid to rest. Slides can be read. Okay, Bayer versus NATCO, this is a compulsory license. 3 questions we are talking about. Reasonable requirement of the public has been met, working requirement, and I'll go through it one at a time, and of course the voluntary licensing. So, reasonable requirement of the public has been met. The data that has been provided to us says that Bayer provided only 2% of the medication which is required in India. Doesn't qualify for reasonable requirement by any standards. The dosage, if you look at it, if you look at what Bayer is costing, it's 2,80,000 INR. And Cipla will have to, NATCO will have to sell it for 8,800. If you look at the pricing, that's like the Zenith and the Nadir. You can talk about, you can equate it to that also. So it's completely different we are talking about. About working, now that was interesting because when the patent office when the case went to patent office said that no, importation does not amount to working. When it went to the IPAB said no, that's not true. The act might lean towards domestic manufacture, but you cannot discount importation. Importation shall be considered working. So there we have got some clarity. The royalty which was getting paid to NATCO was about 6%, which was increased by 1% by IPAB, so now it's 7%, so that's the change. This was another interesting portion which I think wasn't talked about. The thing was that Cipla, the same case where patent linkage happened, so Bayer sued Cipla, and Cipla obviously sued Bayer. So Cipla and Bayer have a litigation going on. But when it came to this particular litigation, Bayer said that, you know, we are there in the market, the Cipla's product. So if you've sued somebody, don't use it as an evidence for yourself. You can't. It's just not acceptable. Either that person can be a friend or they can be a foe. That's it. There is no middle path. That for your own self, you can't say that, okay, my competitor, somebody who I've sued for infringement, is there in the market, so I'm meeting the reasonable requirement of the public. It doesn't work. The argument doesn't work. Okay, moving on. This we know. BDR Pharmaceutical versus BMS. This is an interesting case because the request for compulsory license, which was raised before the controller, was not granted. And the reason why it was not granted, BDR Pharmaceutical said that there has been too much of delay from BMS's side. We have asked for voluntary license, but they are not giving it to us. So we feel there is malafide in intention, so the controller said that no. It is the right of BMS to ensure, to take their time, to feel that they can give you voluntary license. And if they have done so, then it's absolutely all right. So no compulsory license granted. I'll just finish with this slide. Okay, Merck versus Glenmark. I think this is the last case that I'd like to take up because one, it made a lot of clear decisions as far as obviousness was concerned. Here also we talked about Section 8, and the court clearly said that it is the discretion of the court. They will decide. They will decide the intent of the person who has filed it. It is not, just because you've raised Section 64(1) doesn't necessarily mean that the patent will be revoked on that. That is one interesting point. And the last one, if you look, about public interest. Like I said, we harp on that. Emotional packaging, very important. But here, it is very clearly said that merely because defendant who's manufacturing generic version is selling a tablet all at a lower price. So pricing for the first time in this particular case came to the forefront, and the court said that no, it is not a valid argument. Barring that, the rest of the cases are wherever, we have taken on strict interpretation of guidelines and so on and so forth. It's still a very nascent field, and honestly, like all litigation in this world, only lawyers are winners. Thank you.